Okay, I apologize for that. I had way too many pictures and way too many documents open on my computer. So, good news and good news. Okay. Number one, good news is I received documents, but they were not from child support. My federal lawsuit is supposed to have a reply by the 26th. Today is the 28th. And the reason that I'm showing you these documents is, if you remember, I'm also fighting a garnishment order, and this is from the Attorney General. This is the one who is um, enforcing the child support, and this is also the one that is trying to steal my property and give it to the state. So if it takes, and again, sorry about the unfocused, crappy phone. I got one of those. I don't know. It's one of those crappier phones, man. I don't buy Apple products. So anyway, if you remember back, we filed our federal lawsuit, and they are supposed to reply. And I did get something in the mail, but it was about the garnishment order. I have not gotten anything from child support, and the reason I'm bringing all this stuff up is, if you look at these documents, this is coming from the Attorney General. It's not signed, just has their name on it. This is fraud right here. This is not an affidavit. This is all hearsay. This is the 23rd when they wrote it up, and the envelope, okay, says the 24th. Says it right on there. Says the 24th right there. So, and I got it the 27th, so it takes 3 days. So I'm not counting my chickens yet. I'm not getting too excited because it's only been 3 days, and according to these people, it takes 3 days, and Sundays don't count. So Monday will be their last day that they have to file. But you would also think that they wouldn't wait until the last minute. So, good news is child support has not responded. The good news is that I've got these people on the run with their bull crap that they're trying to do with me with the garnishment order. And we've talked several times about this. Let me just bring you up to speed with the garnishment order. Okay, this is what they're replying to. This was sent September 1st. Okay, and I think we went through this. This is 12 pages of all of my defenses, my replies. This is how they have, done. This is memorandum of laws, how they violated my rights, how they were supposed to validate the debt, and then there's all their case laws that say, what's going on. I even quoted the Constitution in here, right? Inherent in the people, no bills of attainder. You guys remember all this? If not, go back a couple and read it all. But this is basically my reply to their garnishment order, because they think they have a security interest in my property, and they don't. So I waited 10 days, actually 14 days, as you can see there. Okay. And I smashed them with another counterclaim. Okay, this is a motion to dismiss, counterclaim with garnishment and subpoena with affirmative defenses. Okay, and I also sent a judicial notice to the judge, which was a private notice about the administrative process, which I'm not going to share because, again, it's private. So that's one of the things that we're going to have to learn together, is some of these documents, like my address and all this, man, I don't care about putting my shit out there, because I want you to know that I'm trying to be honest and show you guys what's going on. And, I'm not afraid of putting my information out there, because, I want you to just know that, this is real shit, man. This is real stuff going on here. So, and hopefully hopefully this will some of this will rub off on you guys and will help you with your issues you're having. So anyway, we had a garnishment order, okay, that was sent to the boss. And he told me about it, and I said, don't do anything. I will reply. Okay, so we replied with this 12-page document. And after 2 weeks, they didn't do anything. And I talked to my boss, and I said, what's going on? And he said, here's your check. And I said, okay, thank you. So he's not doing anything because I brought up some really good points. And I also sent my boss's lawyer all the information and documents that he is required to have to form a defense. Okay? So that will be something else that you guys might want to look into. So anyway, going back to the motion to dismiss the garnishment order, let's go through this. Okay? So the first thing we do is rebut that they have power of attorney and that they are administering my trust. Okay? You're fired. Having received no response from OSDC, that's the Office of State Debt Collection, which is, by the way, a third-party bill collector. I'm not in contract with these fools. This was what the whole administrative process was about with these people. I sent them a validation of debt letter. They didn't respond. They just continued collection activity in violation of the Fair Debt Collection Practices Act, 1692G. Okay? Let's take a look at that real quick. Okay? Do you remember this one? This is from Jacob Franklin. Okay? This is notice to agent, is notice to principal. Okay? We got our certified mail. This is July 24th. Okay? According to the Fair Debt Collection Practices Act, you have a duty to provide me with documents that show proof of your claim that I owe your agency and that we are in contract. It also states you must cease and desist collection activities until you validate this alleged debt. I would be happy to settle any financial obligation that I might lawfully owe as soon as I have received the following documentation. Okay, we've been through this. It's a one-pager, right? It's nice and easy. Validation of the debt, verification of your claim against me. I want a sworn affidavit or a hand-signed invoice, a copy of the contract, binding both parties, right? They don't have any of this shit, bruh. Okay? They don't have any of this stuff. Now, what he should have done is he should have sent me a copy of the original judgment from 2012, this alleged judgment that happened that, remember these case numbers, they start with, okay, 12, so that's 2012, that's 2012. This one's from 2018. This is just another made-up number. This is AP&P, this is Adult Probation and Parole, okay? This is Utah Department of Corrections, that's the number, okay? So all these different numbers they've made up, created other bonds, created other bills, and they're all false because they've all been sold. They don't have the originals, man. Okay? That's all I want. I just want you to show me the contract. Okay? That's it. I would be happy to settle any financial obligation. Right? Until I found documentation from you. Show me the friggin' contract. Okay. So anyway, they went around the backyard and they tried to do a garnishment order, and my boss is really cool. Like I said, I'm on a 1099 and I'm doing my own thing, and so I'm a contractor, so that's not actually his money. And so let's go through this real quick. This is already 9 minutes, so I'm just yakking. So having received no response from OSDC or any alleged creditors coming forward with proof of claim, proof of a security interest, or proof of being a real party in interest, the authorized representative for the defendant, that would be me, files this motion with proof of a private administrative process is complete for settlement and closure. Administrative process shows estoppel, and a copy has been delivered in private to the judge, and 3 copies of this motion delivered for the clerk, 1 for each case for all case numbers. Okay, so we did that. Copies are attached for each case number. So I made 3 copies of this so that this lazy jackhole nut butt nugget that works as the clerk of the court's little secretary, you know, the little troll at the window, you know, that thinks she's the gatekeeper. Yeah, so here's 3 copies. File 1 of these in each case. Okay, so let's see what we got here. Pursuant to Rule 24A of the Rules of Civil Procedure, the authorized representative of the defendant seeks intervention of right in this action. What? In order to assert the affirmative defenses set forth in this motion to dismiss counterclaim. Okay? Authorized representative has an unconditional right to intervene under commercial and common law, and authorized representative claims an interest in the property or transaction which is the subject of this action and is so situated that the disposition of this action may be, as a practical matter, impair or impede authorized representative's interest, which is not adequately represented by any other party. Now that was a whole mouthful, but that basically means this right here, that is a trust. Okay? That is an all capitalized name, and I have a security interest. How do I have a security interest? Well, I'm glad you asked, because I have a security agreement. So once again, affirmative defenses, right? This is a motion to dismiss the garnishment order and the subpoena that they're looking for records, right? So they can try to find, you know, where my property is and so they can lien and levy my property. And it's my property, dude. It's not theirs. Okay? So here's the motion. Okay? So we're under 24A, which means that I'm seeking intervention because I am the authorized representative and I have a claim to this property. Okay? Here's Rule 12B6, which is the motions. Okay? Rule 7 is actually motions, but 12B6 is your defenses. Okay? Rule 8 is defenses. Rule 13 is counterclaims. Okay? Authorized representative defendant moves the court for an order dismissing this garnishment order. Okay? And tell them to cease and dismiss. Cease and desist. The grounds for this motion are that OSDC fails to state a claim. Okay? They don't have proof that they are a real party in interest. Okay? You can't just say you have authority. Okay? You have to prove you have an interest, a real interest, and a valid contract. Okay? This motion is supported by the reply to garnishment sent by the defendant's representative with supporting documents filed and all other pleadings on file with the court. Okay? And we've been through all that. We're not going to go through that again. All property is held in a trust and is private and exempt from levy. They have not shown clean hands and good faith as seen in administrative process, and OSDC activities must be denied. So these are all the things that I brought up, and there are a buttload of them. Okay? But it basically says, look, dude, I have a security interest. You don't. Okay? I am controlling this property, and I would like to see the contract. Okay? You know what? We're going to read this real quick. This is out of what does acceptance for value mean? So what is value? Except as otherwise provided with respect to negotiable instruments. Okay? That's what that bond is. That's what that charge is. Okay? Whenever you get a charge, it creates a negotiable instrument as soon as you sign it. Okay? That's what all those bail bonds and all that stuff is. Okay. Except as otherwise provided with respect to a negotiable instrument and bank collections, a person gives value for rights if he acquires them in return for a binding commitment to extend credit or for the extension of immediately available credit, whether or not drawn upon, and whether or not a chargeback is provided for in the event of difficulties in collections. Okay? As security for or in total or partial satisfaction of a pre-existing claim. Okay? That's my obligation right there. Okay? I'm security, right? Well, if there's a pre-existing claim, prove it by accepting delivery pursuant to a pre-existing contract for purchase, generally in return for any consideration sufficient to support a simple contract. Okay? So, yeah. You want me to be the security? You want me to, discharge, charge back, set off? What you want me to, okay, settle this account for you? Show me the frickin' contract. A person gives value. He gives value to get rights. If one person is giving value, another person is asked to give rights in exchange. Both giving value. Okay? What did child support give you? What did the state of whatever give you? Both giving value and giving rights meet the element of consideration. If they're not giving you anything but a document they want you to sign, right, and give up all your rights, there's no consideration. The question has to be, what constitutes value? In today's commercial system, where ownership is not the prime focus, it's interest in things that takes the place of ownership as the goal. A security interest constitutes a right to seize control of a pledged thing if the one giving the security interest fails to perform as agreed. Okay, well, I haven't failed because all of my documents say right in them, I would be happy to perform as long as you show me the obligation, right? Okay. The one giving a security interest retains possession of the thing that secures the right of another party to seize possession of a thing that backs the security interest that was given. Here's the best part right here. The one receiving a security interest becomes a secured party, especially if the instrument establishing the security interest is registered, right? So what do I have registered? I'll give you 3 guesses and the first 2 don't count. Once again, the defendant has the right to see the judgment. Defendant has a right to have an alleged creditor, debt collector, produce the instrument that shows the agreement, produce the agreement binding the defendant, or defendant will assume no such judgment is in the hands of OSDC and they are committing fraud and placing secured party in harm's way. Okay? Authorized representative moves this court to dismiss the garnishment order and subpoena for lack of standing, lack of subject matter jurisdiction, and lack of a security interest. Representative moves the court to cease and desist collection activity regarding defendant in all cases stated above and any further case numbers that might appear for non-compliance of state and federal law and for lack of providing defendant with proper procedural due process. Order OSDC to produce the contract. Order OSDC to produce the original judgments they are allegedly enforcing or order them to cease and desist. Authorized representative also moves the court to compensate defendant for damages in the amount agreed in the legal notice and demand. We've been through that before. Copyright breach, that's $500,000, and FDCPA, which is $1,000 in the amount stated in administrative process, or whatever amount this honorable judge sees as good and just. Okay? So, yeah, maybe I'm playing with them a little bit. Maybe I'm just having fun. Maybe I'm just bringing up a bunch of shit that, doesn't apply. I don't know. But I'm hitting these fools with everything I got, man. And I'm replying and I'm doing motions and they're not getting my money. It's my money, not yours.